Evening and welcome to the San Gabriel Chamber of Commerce's Educational Forum. Tonight we are going to be presenting some updates on employment law and worker compensation. There were a lot of changes that came forth in 2021, and we wanted to make sure that we right away rolled those out to you. And so we are looking forward to sharing that information with you tonight on workers' compensation updates and employment law updates. My name is Sandy Roscoe, and for the last 14 years, I've been the executive director of the San Gabriel Chamber of Commerce, a phenomenal chamber. And it's been a privilege to do that. And our chamber is incredibly blessed to have a wide variety of attorneys representing every area of the law. So if you find yourself in need of an attorney for any need that you might have, please contact our chamber because we have a legal expert that can help you. Tonight, we have three of those attorneys that are going to help us with this presentation. We have Jean Power, the law offices of Scott Warmoth. We have Paul Chang and Associates. And we have Joseph Fondle from Fondle Law. So without any further ado, I'm going to introduce Paul Chang to take it away.
Well, thank you so much, Sandy. I'm so excited to be here. I'm going to be starting my PowerPoint shortly. Just wanted everybody to know that we are going to be recording this. This will be available to people and we'll put it on our website. So really, I'm excited just to be able to begin. All right, so let's start. Okay, so today we are going to be talking about employment laws in a COVID world for the 2021 update. Just FYI, I have my screen in front of me, and so I won't be looking at the camera, but I'm just going to be looking at the PowerPoint. And if you could please mute your phones as well, that would be great. Quick disclaimer, this presentation outline, the presentation itself are for general educational purposes only. And it's not to provide any specific advice or legal advice about what to do in a particular case. You should really seek counsel. You can be able to speak with Jean or Joseph about your specific issues of the case. Although I am a city councilman for the city of Arcadia, I do not represent the city of Arcadia for purposes of this lecture. In fact, sometimes, as an attorney, I'm going to have a very different view than if I was on council, just because the hats are going to be different. Special thank you to our president, Alexis Salamanca, who puts our Zoom together. And just does so much for our chamber. So we wanted to say thank you to him specifically, himself, as well as Officezilla, as well as his design company. Thank you so much for always putting our Zooms together. Here is our lecture plan. Why employment law? Why is employment law even necessary? The second one is the basics of employment law. The third one are prior laws that you need to learn. And then we're going to really jump into 2021 laws for employment that you need to know. So here are today's lectures. I'm going to moderate the event. My law office does real estate business and labor compliance, but more importantly, we have two very important people that are going to weigh in. We have Jean Power. She is from the law offices of Scott Warmoth. She is focused exclusively on representing employees in discrimination, wrongful termination, and wage and hour complaints. Her website is www.law888.com, so it's actually pretty easy to remember. The next person we have is Joseph Fondle. He's one of the few experts in California that handles workers' compensation cases for both plaintiffs and defendants. And typically in workers' compensation, you pick one side. But fortunately, we have a person that can be able to work on both sides of the aisle, and that is Joseph Fondle. His website is www.frondelawfirm.com. So one of the concerns that I have is that prior to understanding COVID laws or 2021, you have to remember one thing. California has not suspended any of the current laws. For example, you can't legally discriminate against somebody, you can't wrongfully terminate, and you can't fail to pay your employees' wages. I believe that as soon as COVID's over, there's going to be a slew of lawsuits that are going to be coming in but they're not going to be related to COVID. They're going to be related to many of the violations that are typical violations: wrongful termination, discrimination, retaliation. Those are the issues that are really going to be coming in. They just haven't been filed because a lot of the law firms aren't going at full speed. I'll give you an example. Labor Code 558.1 says, any employer or other person acting on behalf of an employer who violates any order of the Industrial Welfare Commission may be held liable as the employer for such violation. For purposes of this section, the term other person acting on behalf of an employer is limited to a natural person, a human being, who's an owner, director, officer, or managing agent. What does that mean? Labor Code 558.1 was already there before COVID. And what that means is, if you're a CEO of a company, if you're on the board of directors, if you're a managing agent of a company, you are personally liable for wage and hour violations. Personally liable, not just your company, you. That has not changed with COVID. And why is that important? Because if you don't understand why laws are occurring, if you don't know the prior laws that are in place, you're going to get sued. And again, likely not for COVID. So why learn about labor law, which is very important? In 2010, the entire federal court system had 895 cases per year. The state of California, 1.2 million cases. So one state had more cases than the entire federal court system, and over half were employment laws. The laws are very different in the United States, very different in California than the rest of the world. Employment laws really hit small businesses. What's a small business? Under 25 employees, under 15 employees, it could crush you. Now, what ended up happening in the last time I did a look back was in 2017, 2018. Well, the federal court cases went from 282,895 to 374,293. But take a look at California. 1.2 million cases in 2009, 2017, 6.2 million cases. Half of them were employment. This is the reason why you need to learn about employment law, because the more you learn about employment law, the better it is for you on how to grow your company. And if you're an employee as well, there are many more lawsuits out there. So very quickly, and just to let you guys know, the first part of the lecture that's not related to 2021, but just to understand the law, is going to be done by me. And later on, we're going to be shifting over to Joseph and Jean so that they could be able to speak about 2021. So just FYI, if you're curious. So attorney fees. The law is that each side bears their own attorney fees unless there's a contract or statute. Well, in California, all the laws for employment, a majority of them, allow for one-sided attorney fees. And I'll explain what that means. This is different than Asia and Europe. So just let you know, most countries follow European law, which is whoever loses, pay the other side's attorney fees and costs. So if you're in Canada and you are suing your employer, if you lose, you essentially have to pay the attorney fees of your employer. However, in California, the statutes are one-sided, meaning that if the employee wins, the employer must pay the attorney fees and costs of the other side. But if the employee loses, the employee does not have to pay the employer's attorney fees. The only way that happens is if the employer resues the employee, and he needs to show malice. And what malice is to show, one, that it was totally fraudulent, totally fake, and two, that no attorney in their right mind would have taken on that case. 13 years, I've been doing a lot of employment cases, well, about 15 years now, but not one employer has resued their employees to try to get back their attorney fees. Very quickly, the general startups between companies here and companies in a foreign country is that in foreign countries, you can't open unless you comply with the law. For example, if you open up in China and you hire employees, you have to have insurance and employee handbooks before they even allow the door to be open. That's very different in the United States. In the United States, they allow you to open up whatever you want, and nobody's going to come and tell you you can't open. But once you open and you violate the law, guess what? You get sued, you get prosecuted. So this is very different. For example, if you open up an insurance company, any city is going to let you open it up. Any city. You don't have a license. It's illegal. You open it up, guess what? Then you get sued. Then you get prosecuted. So in America, it's very different, where the government takes a back seat, lets you make your choices, then teaches you what is illegal or legal, obviously illegal, when they begin to go after you. Very quickly, the law breakdown. US law is broken down into two main components: criminal law and civil law. Very easy to understand. Civil law are split up into two parts: contracts, no contracts. So the contracts are on your right, for example, like real estate, and no contracts. So a civil non-contract claim is going to be called a tort. And a tort is split up into three types. The first type is called an intentional tort. The next type are called negligence claims, and the third one is strict liability. And the reason why this is very important is when you go speak to an attorney, whether you're a plaintiff or defendant, an attorney that does civil cases are going to have in their mind, is this a contract case or not a contract case? If it's a tort, is it intentional, negligence, or strict liability? What is an intentional tort? An intentional tort means that the defendant needs to have the intention to do the act. And if they do it with the intention, they lose. So for example, someone sues you for hitting them. That is called battery. The requirement for battery is that you need to have the intent to hit someone. What about as a defendant, if you had a stroke and you just flailed your arms in the air and hit somebody? Well, I could be able to tell you that the plaintiff would not win. Why? Because the defendant has shown that they did not have the intent to hit the plaintiff. They had a stroke. So that's an intentional tort. What is negligence? Negligence is a duty created by society, and you fall below that duty. And once you fall below the duty, you're liable. Two cars, you're in the back and there's a car in the front, stopped at a red light, no fraud. You hit the person in the back. Who loses? Person in the front, person in the back. The person in the back. Why does the person in the back lose? Because society has said that when there are two cars parked at a red light, the person in the back needs to be more careful. And therefore, because you were less careful, you fell below the duty that is given to you as a driver, and therefore you lose. Strict liability. Strict liability means if it happens, you lose. If it happens, you lose. So for those of you that have dogs, everybody knows the law in California. If it bites somebody, you lose. Why is that? Well, strict liability. Why is that important to you? Because employment laws in California, very few of them are intentional torts. You don't need to have the intention to violate the law. So a lot of times employers will come to us and say, I didn't intend to sexually harass somebody. And it takes a lot of education for you to explain to the client, I'm sorry, this is a tort that does not require intention. As long as it happens, it's illegal. There are 4 types of lawsuits. This is very critical in the employment law claims: workers' compensation, discrimination, wrongful termination, and wage and hour. I just want Joseph really quick to talk about workers' compensation. Joseph, what do you typically see in workers' compensation on the defense side? I'm going to talk about defense just because although there's more applicants, but I'd like you to be able to share, what do you typically see for workers' compensation cases on the employer side?
Well, so there's a couple things that we usually see. Number one, unfortunately, we still see a lot of employers who don't carry workers' comp insurance. And that is a significant problem because once a person either gets hurt or claims that they've gotten hurt, and the employer doesn't have insurance, then they're going to have to face that lawsuit on their own, just like as if you and me decided not to buy car insurance and we got in an accident. We would have to face the lawsuit alone rather than being able to just hand over our insurance card. So that's the number one thing that we see a lot of from the employer. And then number two is that for employers who do have workers' comp insurance, we still see a lot of situations where they don't interact well with the employees to be able to help to kind of get a full picture of what the employee is claiming that happened. A lot of times there's no video on site. They do a poor job of talking to other employees to try to confirm the injuries or the allegations. That's something that we see, and that can make it a lot more difficult for the insurer that you do have to really defend the claim for an employer. So those are kind of the two areas that we see a lot of from the defense side, Paul.
Well, what ends up happening, because you have a very good point, is that workers' compensation, there's no work comp. How does an employee, let's just say that, the employee is an independent contractor, they don't know if, they're just paid cash essentially, and they get injured. And the employer says, well, you know what, I'm sorry, I don't have any workers' compensation. How does a worker, can they still file a lawsuit? I mean, can they still get their benefits? I mean, can they go to a hospital, or are they kind of out of luck?
Well, it's a lot more difficult than if, they're clearly an employee and there's insurance. It's a lot easier if that's the situation. But the short answer, and there's a couple parts of that, and one of which we're going to talk about later, is the independent contractor issue. But, yes, they can still pursue their benefits against that employer. It will be more difficult to get them, especially, medical treatment. They'll have to do a lot of that on their own, but they can still pursue all the other benefits to be able to recover that from the uninsured employer. Independent contractor status in workers' comp now, just like with wage and hour, is basically a dinosaur. It's almost non-existent at this point, unless you truly have your own shop and you are, running your own viable business and you're just out on call for somebody. There really are, the old independent contractor stuff is really just been legislated away. So yes, those employees are going to be able to pursue those benefits. There are avenues. They can file a civil lawsuit against the employer. That's one of the things that they can do. If a business doesn't have workers' comp insurance, they can file both the workers' comp claim and the civil lawsuit, and they can pursue, more damages by the civil lawsuit than they could from the workers' comp, because then they can get pain and suffering, lost future wages, things that would be available in a traditional personal injury case.
So you've actually just made a point. We'll obviously talk about it later, but in terms of independent contractor, is it difficult to be an independent contractor now in California? That's the first question. And the second question is, what about if the employer just says, look, you're an independent contractor, and the worker doesn't know what to do? Can they still come to you as an attorney and say, hey, can you take on my case?
Yeah, absolutely. So, with the question of whether someone's an independent contractor is still, subject to litigation, right? Just like any other disputed issue. So what an employer classifies a person as really has minimal, if any, relevance, especially now with AB5. But even under the older Barrello test, just giving someone a 1099 and having them sign one of those things that says, I agree that I'm an independent contractor. That's all evidence, right? But it's not evidence that has much weight or much strength. So, employees who are not sure, they should always consult an attorney and say, hey, this is the relationship I have with the employer, and I got hurt, and, do I have a case? And most of the time, the answer is going to be yes. You should file a workers' comp claim. More than likely now, especially if the case is really, litigated correctly, they will be determined to be an employee. And then, you're entitled to all the benefits that an employee has.
All right. The second issue is the discrimination lawsuits. And the examples, I just give a few, are race, religion, age, sex, as well as sexual harassment. And Jean, do you, now during COVID, do you still see sexual harassment occurring? I mean, is discrimination still ongoing? I mean, what's going on with COVID? Are there, I mean, has sexual harassment stopped? Has racism stopped?
Well, you probably know the answer to that. Sadly, no, it hasn't. There really is no upside to COVID at all. But yeah, we are flooded with plaintiffs' employment law cases, even during COVID. We'll talk about COVID specific issues, but like you said at the beginning of your presentation, the laws that existed before the pandemic are alive and well today. And I have been inundated with people that have been discriminated, a lot of race discrimination. A lot of people are still working in their offices. Some offices more responsible than others in terms of distance and everything. And there's still issues of women not being accommodated for, let's say, lactation facilities, or people who are have a different country of origin are discriminated and not given the same opportunities to, let's say, meet with certain clients because they might have an accent or something. And so the number one type of discrimination cases I'm seeing right now are based on a country of origin. Race discrimination and national origin and race are very close, but it's mostly national origin. And I still see that, yes.
Yeah, I think Jean's point is very well taken, is that, and I'll speak from the employer standpoint, we still have a lot of lawsuits as it relates to discrimination, race, religion, sexual harassment. From the employer standpoint, they basically feel, look, there's been a really bad employee for a long period of time, and now during COVID, they're even worse.
Yes.
And we need to do something about it. And so that's kind of risky about doing something about it in the middle of COVID when you didn't do anything about it before. And so I think Jean's point of there essentially being more lawsuits, sometimes even from the employer standpoint, they exacerbate an issue, a problem even more. But in terms of wrongful termination and retaliation, there are two main types of wrongful termination types of cases that I've seen. And one is that you terminate them based upon something you know to be wrong, like race, right, or age. But the other one is wrongful termination based upon a good faith held belief, meaning that an employee is terminated or retaliated based upon something they believe in good faith, but it could be wrong. So I'll give you an example. Let's say an employee comes to you and they say, in California, you get 2 weeks of vacation a year. Everybody else does it, therefore it's the law. Or they come to you and they say, I work on Christmas, therefore I should get overtime because Christmas is a national holiday. And the employer says, wow, you really believe that? That's great. You can tell the person in the unemployment line how you feel, and therefore you can tell me later on, after I fire you, you can tell me if you're right or if I'm right. That's wrongful termination, even if the employee is wrong, as long as they had a good faith belief in what they believed, then it's going to be a violation if you wrongfully terminate them. But here I have a question again for Jean. Now, here is the big problem. COVID now is here. What does an employer do? And there's no easy answer because I don't have an answer. What do you recommend? Because now you're on the plaintiff side, right? You're able to hunt for cases and look for errors. But what would you recommend now when, whether it's the employer or the employee, someone comes in and they say, I think the law, I feel unprotected as an employee, right? There's COVID all over the place and you're allowing people to walk around without masks. What does an employee do in that regard?
Well, I am encountered with this a lot. In fact, I talked to somebody today just about this very thing where the employer did the right thing. So I had an example of a woman that she was experiencing symptoms. Her employer said, you need to go home, you need to get tested, you need to self-quarantine. And she did not have very much paid time off, paid work, but they could they could make her take leave without pay. And then there's other ways she could apply for some benefits during that time. And what the employer did right there is they had their policies for COVID laid out. They had met with a lawyer. They had already told all the employees in advance, if you have symptoms, this will happen. You will be asked to leave. You will be asked to test. As a plaintiff's attorney, I'm not going to be able to do anything to help her. On the other hand, I've seen some bad cases where I've seen employers just flat out tell somebody, well, you have COVID, so you leave. I'm going to go ahead and fire you because I'm going to hire someone that doesn't have COVID. That you cannot do. That you can get sued for. But as an employer, and we all have jobs, we work at places of employment, you have to be vigilant. You have to follow the rules, and you have to put people on notice of what the rules are, which would reduce the likelihood of you seeing any action from a plaintiff's attorney like me.
The last groupings of lawsuits that I typically see are wage and hour violations, overtime, meal break, rest break, time card violations, and misclassification. Overtime, just to go over very quickly, is that if you work over 8 hours in a day, then you're going to get overtime. If you work over 40 hours a week, you also get overtime. However, overtime is calculated both by day and by week. Whatever is higher, you need to pay to that person. So I'll give you an example. Let's say a person works 10 hours a day. That's 2 hours of overtime. But on the sixth day that they work 10 hours, it's not 12 hours of overtime. It's actually 20 hours of overtime. Why? Because they've worked a total of 60 hours, which is 10 hours a day multiplied by 6 days, minus 40, which is 20. If you did daily overtime, they only get 2 hours a day, which is 12 hours of overtime. So you need to give them the higher overtime rate. Meal breaks, for every 5 hours of work, you get a 30-minute meal break. If they work 6 hours or less, they can waive their first meal break, but it needs to be in writing. Rest breaks, every few hours, you need to give a 10-minute rest break. Time card violations, even though if they're working at home, they still need to document their working conditions. And then there's misclassification, which Joseph spoke about earlier in regard to misclassification. He's going to be going into detail as it relates to misclassification. Next slide. Very, very quickly, I just want you to know, I believe that if you really want to learn employment law, you got to start off in 2019. That is when a lot of laws change. So what did I do? I put all the 2019 relevant laws for you. And I'm just gonna go straight through it. I'm not talking about it, but just let you know, a bunch of laws, some of them public, some of them private, but this is where like the sexual harassment training came into place. This is where lactation law came into place. So what we did is we listed all the laws for you. You can slowly be able to go through them for your relevant industry. Okay, so I did quite a lot. But again, if you want to know how to be a good employer, or if you're an employee and think there's a violation of the law, many of the violations stem from the 2019 laws. 2020 and 2021 only added to the 2019 laws. So very quickly, a 2019 law that's very, very important basically says, this comes from the Me Too movement, and it says that if there's a contract or a settlement agreement which keeps a person from testifying about sexual harassment, that's illegal. That's illegal. Why is that important? Because I still see settlement agreements in which the employer tells an employee, I'm going to give you money, you cannot testify, and that is void and unenforceable. Now, I have a personal opinion about this. I am part of the Me Too movement. I've shared before that when I was a minor, I was assaulted by a physician, right? And it was a terrible experience. And so I've been part of the Me Too movement. But I do want to say this, less employers are willing to settle sexual harassment claims when the employer knows that you can still testify about the sexual harassment. So unfortunately, because of this law, more cases are going to trial on sexual harassment than ever before. Because typically an employer wants to settle the case, get out of the case, and not have you go out and say that you've been sexually harassed. So this is actually re-victimizing the victim. And that's been very unfortunate in regard to sexual harassment cases. That's effective 2019. Another one that's very important is that Senate Bill 785 in 2019 basically said that a person's immigration status has no relevance whatsoever in employment cases. Why is that important? Well, before, employers used to basically come after the employee and say, are you legal? Are you legal? Are you able to work? And that really scared a lot of employees from suing their employer. So immigration status is not an issue. So if you are a plaintiff and you want to sue, you may have been working illegally. And the question is, Joseph, would you take on a workers' compensation case if the employee was illegal?
Yeah, absolutely. I mean, I've represented many undocumented and illegal immigrants in workers' compensation cases, both in my practice and in years before I opened my own practice. So yes, I mean, I would not have a problem with that because they're entitled to the same benefits under the law as anyone else. They have to, as long as can prove an injury at work, their immigration status or lack thereof makes no difference at all. And it is true that employers tend to try to use that as a way to go after someone who's claiming benefits when they can't prove their status. And this law makes it a lot easier from the applicant's side to be able to shield the client from having to answer those things. There was a
Okay, so I'm going to throw a twist, and the funny thing is I've not prepared any questions for any of the speakers. So this is the expertise that they have. So it's incredible. But what about if an employee, they're illegal here in the U.S., they've been using somebody else's social security number? Can they still sue? I mean, can they still have their rights? I mean, what about they just haven't been above board and they, maybe used an alias? I mean, can they still be able to sue? Would you still be willing to take on a case like that?
Yeah, absolutely. I've had a couple of clients back years ago who had used as many as 5 or 6 different social security numbers. That's relatively common with a lot of the undocumented workers that come here. They'll have used several. So it doesn't have any effect in the workers' compensation arena. It absolutely has no effect other than some minor implications as to calculation of benefits through the state. If they get benefits from EDD, there may be some complications there, but it's just a complication. It doesn't have an effect in terms of the overall merits of the case.
What about Eugene? Are you willing to take on a case of an undocumented immigrant here in the United States? Does that bar them from coming to you and saying, hey, look, I've been sexually harassed? Would you reject a case based upon an undocumented immigrant?
Absolutely not. Probably at least 60% of my clients are in the undocumented community. And to add to Joseph's point, not only do you have rights, and there are some, like with EDD unemployment benefits, that does prove problematic. But in terms of sexual harassment, wage and hour issues, not only do you have rights to pursue your wages that are owed you, an employee cannot retaliate against you by threatening that I'm going to report you to ICE. Those words have been said, by employers to clients. And you can't treat an employee differently because of their status. Like, I'm going to pay you in cash and not pay you overtime because you're undocumented. So not only do I take those cases, but employers can suffer consequences for trying to threaten an employee with, reporting or treating them differently, and that undermines their ability to work just because of their status.
And it's good. Typically when we give a lecture, it may feel really one-sided, but today we have just an excellent panel, which is that we have both plaintiff and defense counsel here. So it's important to hear all this. Just very quickly, this is in conjunction. I skipped over. It also relates as well to the sexual harassment. You can't have it in a settlement agreement. Settling the sexual harassment while also saying that they cannot go out and talk about the sexual harassment. So again, both this one and the other one are pretty much identical in regard to confidentiality, not being able to disclose. Lactation accommodation. This is something that sprouted out in 2019, and I would like Jean to talk about lactation. And also, Jean, if you can, in terms of the lactation, there are two questions after you explain lactation I would like you to elaborate on. And although you're on plaintiff side, is what about if an employer's place is really small? Like, it's just a really tiny area and there's an inability to provide a lactation area. What ends up happening there? And then the second issue becomes, in terms of lactation, is earlier you talked about COVID. Does an employer have to provide lactation accommodation when the employee is working at home? I've struggled with that. I don't have an answer for that, actually, and I'm hoping that you do. So if you can kind of discuss lactation just in general. Again, it started off in 2019, but in 2021, there were more laws related to it. And then to talk about what about if there's no room at an employer's place for it? And then what about if employee is working at home due to COVID and there's lactation needs there?
Okay, well, some of these are what we call emerging areas of the law
Yep,
that
absolutely.
will be subject to litigation. But first, to explain lactation accommodation. So this is for women in the workplace or breastfeeding their children, and then when you return to work, they need a place of privacy in order to, express their milk. And for a long time, women weren't really given facilities to do that, which gave rise to these laws. Specifically, for a long time, employers were able to say, well, we have a bathroom, go in there. But any of you women out there who have dealt with this issue knows that that is not a sufficient location to do something like that. It just doesn't work. And, there's a privacy element to it. There's a sanitation element to it. So my read of the law, the way I look at it is clients I've had that have come to me about this, almost all of them, about 80% will say, if they ask their employer, can you set up something for me where I can have some privacy, the employer will do what they can. They'll put a separate office just for them. It can't be used for any other purpose. You can't tell them to go to the break room. Where the problems give rise for employers is as Paul stated, what if you have a small office? What if there physically is not a place to do it? The read of the law is that employers need to make reasonable accommodations, reasonable places. I've seen some employers, make arrangements with depending on where you're situated, with a nearby office where they can do it. I don't know the answer to that, but they need to show efforts were made, that there were discussions had, something like that, try to work with the employee. As for working at home, I have not experienced that. I would think that if I was working at home, it would be easier for me to accommodate myself when it comes to lactation requirements. If an employee is working at home, more important than the actual structure, the employer needs to give time. And the time can run concurrently with their rest periods. And if it lasts a little longer, that's okay. You don't necessarily get paid for it. So that's probably the best answer I have. And I wish I could give a more specific answer, Paul, but this is an emerging area.
No, I think it's so amazing. It's so amazing that you've actually provided probably the best statement that I've heard so far. Frankly, employers ask me, I really don't have a really good answer for that. But hearing it from a person practicing exclusively plaintiff's law, which is, look, you need to just do what you can, right? I mean, look, if your office is 50 square feet and there are two people there and the employer says you need to breastfeed, it's 50 square feet, I'll walk out of the room. From your side, that's pretty much all you can be able to do. And employers have become so scared, they don't really know, particularly male managers or male business owners, they're so scared now because they don't know what to do. But to hear from a plaintiff side attorney, exclusive plaintiff side attorney that says, you know what, just do what you can.
Right.
Do what you can. And also, I think it's very powerful to let everybody hear that essentially that lactation accommodation in 2021 also requires time. You need to give time to the employee to be able to feed their baby. And when you don't and you just penalize them for it, it's going to be illegal. And I frequently forget to remind my employers to do that. Frequently it's, everybody's working, and about lactation, but the last person you think about is the working mother that just had a baby, and you don't think about the accommodation for it. And then what ends up happening is you end up running into a lawsuit. So thank you so much for saying that. I just think it's
And I will add this one thing. When it comes to a jury, if you get there, or a mediator, or just anyone evaluating your case, if an employer just tries and comes off reasonable, they're probably going to be okay. It's the ones where employers are defiant or dismissive is what gives rise to getting sued.
Well, thank you. Next law, I think is very important, one that you need to learn. Again, this is in the 2019 arena, is Assembly Bill 2138. The reason why this is very important is on employee side, an employee may feel that because they have a criminal record, that they cannot be able to get a license in the state of California. That's untrue. If 5 years have lapsed, according to Assembly Bill 2138, unless the crime was a violent felony or is directly or adversely related to the qualifications, functions, or duties, they're essentially going to give you a license. So if it's exceeded over 5 years, you're pretty much home free as an employee. Now, here's the problem, is that a lot of employers that are employing people with licenses believe the government has already done a background check, and they have. But with Assembly Bill 2138, you may not be getting who you think. So that's very important for everybody to know. AB5. This is something that is very critical, although I didn't put Joseph's name on it. Joseph, can you take it away in relation to AB5? And I will, when you want me to flip to the next slide, let me know. Joseph earlier talked about AB5. AB5 is Assembly Bill. So if it says AB, it starts off at the Assembly. If it's SB, it starts off from the Senate. So the state of California also has two branches of its legislative branch. So the state Senate is like the Senate over in the Congress, but for the House of Representatives, it's called the Assembly. And so Assembly Bill 5, Joseph, if you could be able to take it away, and the next slide, let me know.
Okay, thanks, Paul. Yeah, so Assembly Bill 5 was a legislative response to a case that had come down called Dynamax. And it was a case that made rules on who is an independent contractor and who is an employee much clearer for the most part than what they were before under the older Supreme Court ruling from 1989, the Barrello case. And so when you think about the relationship between an independent contractor, the difference between an independent contractor or an employee, we look to AB5 now primarily as the way to make that determination. As I said before, the law has pretty much gotten rid of independent contractors for all but those who are independent in the most true sense. So if we look at this, bullet number 2, we look at the requirements being free from the control and direction of the hiring entity, i.e. the employer, in connection with the performance of their work. That kind of goes back to the old common law test where, courts would look to the level of control that the employer had over the alleged independent contractor. How well did they control their hours, their breaks, what kind of work that they did? Did the alleged independent contractor use their own tools or the employer's tools? And there was lots of different factors that you would look at. And that is still part of the analysis, but it's bullets 2 and 3 that have really weeded out almost everybody from being an independent contractor. So you look at number 3, in order to be an independent contractor, the person has to perform work that's outside the usual course of the employer's business, right? So, you know, if you, for example, let's say, you know, I see quite a few of these here recently, truck drivers, you know, a guy has a CDL, he has his own rig, but he hauls loads for company ABC, and company ABC wants to say, yeah, you're an independent contractor, but he only hauls them for company ABC, and ABC's business is not, they're not like a manufacturer, you know, or a wholesaler, they're a trucking company, right? So when we sit down and do the analysis, is this person going to be an independent contractor? No, because they're performing work that's in the usual course of, you know, the employer. You know, they're doing trucking work for a trucking company. So that has weeded a lot of people out from from employers being able to make that argument that, okay, they're an independent contractor. I had them sign this thing saying they're an independent contractor. I pay them with a 1099. They use their own truck. You know, sometimes they even use their own trailer, but they're doing work that is the company's work, you know, and so that one is going to trip up a lot of employers. And then we have bullet number 3. So if for a person to truly be an independent contractor, they have to also be engaged in an independently established trade or business that's the same as what they're doing for the employer. So using our truck driver example, in order to be an independent contractor, this person would need to be like running their own trucking business, you know, and hauling loads for a variety of different people. That's assuming they could pass bullet number 3, which I don't think they would be able to in this particular situation. But let's say they could. We take a different example. Let's say we have someone who does plumbing or heating, ventilation type work, and they go to a business that doesn't have anything to do with plumbing. It's a restaurant and they're working there kind of as a handyman or doing something. But let's say they don't have their own established kind of heating, ventilation, or plumbing business. They don't do this for anybody else. You know, they don't have, you know, trucks with their name on it. They don't advertise that they're a plumbing and heating, ventilation type service. That person's not going to be an independent contractor, because most likely in litigation, it's going to be seen that they're really just working for the employer, doing stuff for the employer, kind of as sort of like a plant manager or a general maintenance person, because they're not doing this for anybody else. They don't have their own plumbing business that they're advertising, you know, online for. It's, you know, so when you look at bullets 3 and 4 taken together, those are the 2 that pretty much make it. I tell my employers when they come to me, I tell them that it's pretty much impossible to have an independent contractor now, you know, unless this person has a functioning business that's registered and they only come to you when you call them. They give you, you know, paperwork. This is the job order. Without all of that, they're going to be an employee. And this is for workers' comp as well as for labor and employment claims. So, you know, the same test is going to apply. The law is clear about that. So, you know, if they're going to be an employee for wage and hour type of claims and violations, they're also going to be an employee for workers' comp. It's going to go both ways. So you can move on to the next slide, Paul.
Yeah. So in terms of one question I have for Gene, if you're an independent contractor, can you still be sexually harassed? Because, you know, that's kind of a concern, right? That, you know, let's just say that you're paid cash, but, you know, you're a worker. Can you still make employment claims as an independent contractor?
Yes, yes. And also, as Joe just brought up, points 3 and 4, they're probably really not an independent contractor to go back to that. And yeah, it is still illegal to be harassed regardless of what type of worker you are, but it always comes down to points 3 and 4.
Okay. Very quickly on the 2020 law for no more arbitration agreements, this is very important. So you cannot have mandatory arbitration agreements in California anymore. So that happened in 2020. So if you are an employer and you are still requiring your employees to fill out mandatory arbitration agreements, that's going to be illegal. just very quickly, I wanted to ask Joseph, can you be able to arbitrate workers' compensation claims? Because a lot of employers, are hoping that you can be able to arbitrate workers' compensation claims. Is that possible?
No, it isn't. There's the jurisdiction and control of workers' compensation claims is exclusively within the purview of the Workers' Compensation Appeals Board. There's no arbitration. The only thing that can be done is if there are certain selections, there are what are called carve-outs, which use alternative dispute resolution procedures, but that's very carefully regulated. There are provisions in the labor code. These are used primarily by governments, like the city of LA uses it, as to a lot of their police and fire. Use a lot of the similar procedures as workers' comp does normally, except it doesn't go in front of the Workers' Compensation Appeals Board. But it's not, even that is not like, well, we're just going to go to an arbitrator of our choice and they're going to make these decisions. Even that, it basically is about 90% regular workers' comp stuff, and it's just a little bit different. In general, most employers don't even know about this. Any employer can do it. There are a couple of larger ones that do it. I know that in the past, Vaughn's had a program that did this. But generally speaking, the answer is no. You can't make an employee arbitrate their workers' compensation just by putting in a little blurb inside of an employment agreement. That would never pass.
Okay, so let me ask you a question, because we're talking about settlement. Can you be able to settle a claim outside of the workers' compensation system? Meaning, worker falls from the ladder and you say, hey, I'll give you $500. And the person says, yeah, okay. And then he signs that he waives his right to go to workers' compensation. Is that allowed in the state of California?
Yeah, no, it's not. So any kind of claim for workers' comp benefits can't be formally and officially and finally settled until it's reviewed and approved by a judge at the Workers' Compensation Appeals Board. So that's the short answer to it is no, you would not be able to do that.
Thank you so much. Next one is wonderful. I'm so blessed to have experts in the field today. So, we are all blessed today. AB 9, the statute of limitation has extended for 3 years for unlawful discriminatory practices. Now, here's a question I have for Gene, is that in terms of the extension of 3 years, right? There's an extension now for 3 years for race discrimination. Does that mean that as of 2020, January 1st, if my claim had already lapsed, statute of limitations has run out, do I suddenly get a bonus of 3 years? I mean, is that how it works in terms of the AB 9? So my question is, and I apologize, I may not be clear. Let's just say that you had a claim, the statute of limitations for sexual harassment ran out in 2015. Does AB 9 suddenly restart the statute of limitation and give you an additional 3 years?
To me, so if it's in 2015, 3 years from that would be 16, 17, 18. I think you would have missed your statute of limitations at that point. I think the way I interpret the statute is if my injury occurred, let's say in 2017, it would have been lost without the statute. So you can only go back 3 is the way I read it.
Yep, that's absolutely correct. So in terms of the statute of limitations, is that if it's lapsed as of 2020, January 1st, it's gone. You're not getting a bonus out of nowhere.
Right.
It's not winning the lottery. Something occurred in 1976.
Right.
And then suddenly you get a 3-year bonus. And Gene's absolutely right, because a lot of people are asking that, they're really scared. However,
they do.
However, if your claim had not lapsed as of January 1st, 2020, and it had not lapsed, you will get a total of 3 years. So let's just say that something happened in June of 2019, sexual harassment. Before it was only 1 year. Well, now you get a total of 3 years from June of 2019. That's very important for people to realize that the statute of limitations now is one of the longest in the United States. And so this is a very critical issue, because before, it was just the 1 year statute of limitations. It's so critical for employers and employees to know that you have a longer time to be able to bring your lawsuit. And let me just ask you, Gene, would it be possible for an employee to come to you because now there's a longer statute of limitations and really deep down inside, they don't want to file a lawsuit, but they want to bring a claim? Do you take cases where you're willing to say, you know what, there's a 3 year statute of limitations. I'm not going to file a lawsuit tomorrow because employees may not want to file a lawsuit right away. Are you willing to take cases where you try to do maybe informal resolution or mediation before you file a lawsuit? Are you okay with that?
Oh, absolutely. People who suffer from these discriminatory practices, most of them, they're embarrassed. They don't want a lot of people to know about it. They don't want to be perceived, as a complainer, but it hurts a lot. And to bring this to a public situation is tough for an employee. And I absolutely respect their wishes to do that. And I've gotten pretty good results doing pre-litigation mediation or an informal resolution of a matter. And I do that when it benefits my client. And believe it or not, many plaintiffs prefer to resolve their issues, especially in areas of harassment and sexual assault, to handle it in that way. And again, I agree with you, Paul, on when we talked about settling cases. It hurts my clients when they don't have the ability to, enter into certain types of non-disclosure agreements, because it does affect their ability to settle cases as well. We need to find that happy medium. But to go back and answer your question, yes, we do pre-litigation settlement, but we are mindful of the statute of limitation. We can't let it lapse. But if we have time, that is the preferred vehicle.
And I would say from an employer standpoint is now that the statute of limitations is really 3 years, is that the employees now have an opportunity to not feel as rushed, because basically what they used to do, they would come to the employer and they would say, look, I only got a 1 year statute of limitations. You need to be willing to waive the 1 year or I'm going to file a lawsuit. And so employers were under a lot of pressure and they didn't want to waive anything because nobody knows what's going to happen. But now with 3 years, the employer is also given an opportunity to try to informally resolve. I think that's so smart. What Gene has said is that, look, doing pre-litigation mediation instead of doing it 2 years later after the lawsuit is filed, the pre-litigation mediation is something that a lot of attorneys haven't been doing. And I really think that, it's just very, very critical that you consider it and you find a law firm that's willing to do it. Did I spell 3 right? I haven't spelled 3 in a long time. Is it
did.
THR?
You got
okay.
it.
It looks so
Paul knows all.
bizarre. Okay. Just very quickly, and then we're going to take a 5-minute break, is that sexual harassment training needed to have been done by January 1st, 2021. And so if you have 5 employees or more, you need to give sexual harassment training. Non-supervisors, it needs to be 1 hour of training. Supervisors, 2 hours of training. If you have 4 employees and you are an owner and you draw salary, you are an employee too. So it's actually very easy to have 5 employees or more. It needs to be done every 2 years. If you hire a new employee and the employee has previously done sexual harassment training, you do not need to do the sexual harassment training again if they've already done it within the last 2 years. So let's take a 5-minute break. We'll come right back. We'll finish up the slides and head into 2021. The government, despite COVID, decided to move forward with new laws. It didn't suspend any of the new laws in the state of California, which is really scary. These new laws will have a huge impact on litigation in 2021, and lawsuits are coming. In fact, lawsuits are coming and California companies are leaving. But before we get to 2021, I did want to provide this information, is that phase 1 is currently being implemented. That's for healthcare workers and first responders for COVID vaccines. Phase 1B, tier 1, are for seniors over 65, and I provided the link for it. I did want you to know that there are a lot of people that have been complaining about going to the first link and not being able to register for vaccine distribution. The first link is the link that everybody's been using. Wanted you to know that there is a update as of this morning at 9:15 that I've been able to distribute. Dodger Stadium has an update on the vaccines. Although the county website does not allow registration for phase 1B, this link does. And so we've been able to distribute this link, and this has been linking over to the Dodger Stadium Vaccine Center, and people have been registering. Hundreds of people have been registering. Really encourage you guys to be able to do it. Don't feel discouraged. This is your ability to be able to get a vaccine, and that second link is the link that will allow you to do it. Okay, very quickly on the return to work. Here is the problem with return to work. I'm gonna want Jean to kind of weigh in on this issue. There's something called guidelines. Guidelines are governmental bodies that provide their opinion, but is not the law. So the guidelines that LA County has provided, some attorneys have been arguing is not the law. However, this is the guidelines that are occurring. The reason why I want Jean to weigh into this is because of the fact that obviously if you're not doing it right, she's going to be poking at you from the plaintiff's standpoint. So the recommendations from LA County Public Health is if an employee is sick in general, you send them home. If there's a contact with a sick employee, whether or not they have COVID, you quarantine for 10 days. If you do have a sick employee, but they don't have COVID and they're able to show it, they can return to work after 24 hours. If they have if they refuse to go to a doctor and they refuse to get a negative test, it's 10 full days quarantine, no exceptions. If there's a COVID positive test, we'll have more information. But I just wanted to provide the two links that related to LA County Public Health. Jean, from your perspective, and I guess there's no real right or wrong answer on this because we don't have any litigation, we have no cases. Do you believe that if a person is not following the county rules, because the county rules are actually more strict than even the CDC rules, I mean, how do you know if an employer is doing something correctly? I mean, where does the employer go? The reason why I want you to talk about it is because really the employers aren't scared about the defense counsel that are representing them like myself. They're worried more about the plaintiff's counsel like yourself. What are you looking at to see if the employer is complying with the law? Would it be LA County, CDC? What is it that you're looking at for COVID?
What I look at is I do look at the most strict guidelines available, of course. But the more important to me, and I brought this up before, is that the employer actually has a protocol, that they actually have.
You know what? I can no longer hear Jean.
Hold on, let me see. Really?
Oh, perfect. Yeah. Okay. Can you start again?
Okay.
What you really look at is what?
What I really look at is, do the employers actually have a protocol? Do they have guidelines? And to me, the easiest thing, what I look at, if an employer says, listen, we're adopting the Los Angeles County guidelines, here they are. Or we're adopting the CDC guidelines, here they are. Now, there's a dispute as to what is more controlling. And again, you bring up a good point. They are recommendations. And if someone is injured, let's say someone gets COVID because an employer didn't follow these recommendations, then there could be a negligence action or something like that. But the most important thing an employer should do is have a body of rules and regulations. And it's real easy just to copy what the County of Los Angeles is doing and follow it. Also, I have talked to plaintiffs that are upset because they lost their jobs because they came to work sick. The employer told them to go home. They refused to go home. Then they got fired for that. That employer did the best that they could. That was probably the right decision when you have an employee that refuses to leave, that is positive with COVID, is coughing everywhere, does have symptoms. Where employers get in trouble is where they force people to come to work, where they don't make their places safe to work. And I know that no members of the San Gabriel Chamber of Commerce is going to do any of that, but because it's not right. But I think the strongest cases are going to be the ones that do have a procedure, whether it's CDC or Los Angeles County, and stick with it and apply it consistently.
Joseph, I wanted to ask you, if a person gets COVID, can they file for workers' compensation?
Yes, yes. We've seen a few cases of that. And we're going to talk more about that when we get to a few slides later. But yes, it's just like any other disease. I mean, most people don't really realize this, but if you contract any kind of disease, and you can always make the allegation it was at work, and if you can show that you got it at work, regardless of what disease it is, then you're entitled to the same kind of medical treatment and other potential benefits as someone who slips and falls or falls off a ladder or something like that.
What about if you're working from home and you get COVID? Isn't the employer going to say that you didn't get COVID at work?
But your home is now your workplace. So for purposes of workers' compensation, and the laws are construed broadly in favor of applicants, most likely what's going to happen in a situation like that is, as long as they are engaged in their work at home and during a period of time that they feel like they may have contracted it, and that it is determined that they did in fact contract it, I mean, they will have an argument. Obviously, the employer or the insurer has the argument of, well, but you probably also out in public, going to the store, maybe riding the bus, going shopping, and you may well have gotten it there. And it just is just like any other workers' comp case where the employee has the burden of showing that it's more likely that they got it at home while they were working, as opposed to when they were, shopping at Ralph's for groceries.
So apart from COVID, if an employer has an employee, and let's say they go to Vegas because they need to do a trade show and they get injured, can the employee still file for a workers' compensation claim even though they're not at the employer's work site? I mean, a lot of employers dispute that. Employees don't know if they can.
Yes, the short answer is yes, and the case law on this is just everywhere. If you really do research on it, going back almost 100 years now, back to the early 1900s when the first Workmen's Compensation Act, as they called it back then, was enacted. As long as the employee is engaged in what we call in workers' comp AOE COE, which is the injury arises out of their employment and happens in the course of their employment. So if they're at a trade show in another state and they're there on work and they get hurt as part of that while they're doing something for the employer, they're going to be considered an employee at that moment when they got hurt, and that injury is going to be considered as having arisen out of their employment, and they are going to qualify for benefits. In fact, I had an employer come to me not long ago about a case of an incident happening out of state, and just because it happened out of state doesn't mean that the person doesn't qualify for benefits here. As long as they were hired here, the employer's based out of here, and they're doing the employer's work while they're out of state, they're still going to qualify.
Okay. Next one, Senate Bill 1383. We're going to have Gene talk about Senate Bill 1383. Just a quick intro. Most people feel that, to be a big company of 50 employees or more, that's considered CFRA. So Senate Bill 1383 amends the CFRA for 50 employees, and we will have Gene take it away.
All right, so now it's down to 5 employees. We call it CFRA. And actually, this is crossing over into the COVID arena, of course. So basically, there's 2 principal components. You have a right to leave for up to 12 weeks in any 12-month period to care for a family member or for an employee's own medical condition. And you have a right to reinstatement for the same or a comparable position at the end of the leave. Now, there are some limited exceptions where an employer may not be able to hold someone's job open for this, but they're difficult hurdles to overcome. Also important on CFRA is the definition of family member has been expanded it used to be for minor children, very limited, but now it can be to care for an adult child who's over the age of 18, the child of a domestic partner, and a grandparent, grandchild, or sibling. And, there's this must have come up, a lot of times laws arise because of facts that weren't handled right in the workplace. An employer of both parents, let's say mom and dad both work for Costco, each parent is entitled to have up to 12 weeks of leave, to care for their child. You don't combine it. It deletes key employee provisions and prior CIFRA provisions, and the provisions elimination removes an employer's ability to fill positions of critical high-ranking employees during their leave. So there used to be a carve out to that. So you need to be mindful of all your positions when someone's out on leave, to do your best to be reasonable. Now, we could get all in the weeds and the laws about what it isn't required, and Paul probably knows more about this part on whether or not an employer is required in every circumstance to hold a job open. Also, it expands available leave to include leave for a qualifying exigency related to the covered active duty, to cover active duty persons, or an active duty employer's spouse, domestic partner, child, or parent in the United States Armed Forces.
Yeah, this is a really, it's pretty serious. Basically, CFRA, one of the provisions, and Gene has gone into it, is the key employee provision, meaning that if you have a key employee in a company previously, and it's just very difficult to fill that position because they're a key employee, you can replace the employee, but now California doesn't allow that. So if you have 5 employees, one of them is, let's say, out of the 5 employees, and you do sales, right? The other 4 employees don't do sales, and your sales guy leaves. You can't replace that salesperson. You can bring in a temp, but once that person comes back, you got to give them the same position. The scary thing is this, that because the key employee provision has been eliminated, the temporary employee that you bring in, you're going to have to pay them unemployment. I know it sounds crazy. So this is an unfortunate law because there was not a step up. It wasn't like this year we're going to make it 40 employees, 2023 we're going to make it 30 employees, 2024 we're going to make it 20 employees. Nothing. It went from 50 to 5, changed everything, and makes it very, very strict and difficult. I am happy, however, that they did allow for covered active duty for military. I think that's excellent. But this law is going to cause a lot of people to leave California, unfortunately. Gene, I'm going to have you speak about kin care leave and the amendment to the use of paid sick leave.
Okay, so as it stated in this PowerPoint, existing law requires an employer who provides sick leave for employees to permit an employee to use the employee's accrued and available sick leave for time off needed to care for an ill family member. But it now prohibits employers from requiring an employee to use the accrued and available paid sick leave. So I talked to someone yesterday about this. They did not want to use their leave, but the employer on the other side of things gave them the option. You can take leave without pay under CIFRA, or you can exhaust, well, this isn't CIFRA, but you can use your leave without your unpaid leave or use your paid leave. It has to be at the option of the employee. So, some people want to accrue their sick leave in case they might have an illness in the future, but they cannot be forced to use it.
All right. Gene, I'm going to have you speak about the extension of time to file a labor commissioner complaint.
So this isn't something I do a lot personally in my practice. Most plaintiffs don't do it, but I have referred clients to the labor commissioner when they have a smaller wage claim, or an employer owes them like $600 or something like that. So existing law generally permits employees who believe they've been discharged or otherwise discriminated against. They would have 6 months to file their complaint with the labor commissioner. It's been extended to 1 year. In addition, the bill authorizes courts to award reasonable attorney fees to a plaintiff who prevails in an action where an employer has made, adopted, or enforced a rule, regulation, or policy that prevented an employee from disclosing information to certain entities or from providing information to or testifying before any public body conducting an investigation, hearing, or inquiry, or for the retaliation of an employee for participating in such protected activities in accordance with the labor code. That's effective this year. And I think what's important here is if you owe that employee like $600, it's just cheaper to pay him $600 instead of having to pay attorney fees through a labor commissioner action.
Joseph, I'm going to speak to you about AB 3075, the shame to pay law. Joseph, you're muted.
Oh, I'm muted. There we go. Sorry. Yes. So if we take a look at this, this is another one of the many new laws that businesses are dealing with, and especially smaller businesses are the ones that get hit with a lot of these new rules much harder than the bigger ones. So if we look at this, the new law 3075 is an amendment to the Corporations Code, and it requires when you're filing your statements of information and formation documents as either a corporation or an LLC, or you have to give certain information on those statements. And one of the things that now is required is that when those documents are filed, if any director or member or corporate officer of the business that's filing has an outstanding judgment issued by the DSL, the Department of Labor Standards, for a violation of a wage order, that has to be listed there. In other words, it's kind of like, because these are public records, right? So, when we do business searches, we can go on the Secretary of State's website and we can, find out some information about businesses. And now you're going to be able to see really clearly, somebody comes to me and they say, well, I've been working for business ABC, and I go and look them up, and all three of their officers, have judgments against them for not paying their other workers. And you're coming to me saying you haven't been paid by them. Wow, what a surprise. So it's something that was put in place to try to kind of, like, as you say, shame to pay. In other words, we're going to kind of out you publicly if you don't pay people. And so we'll see how this goes, whether it has the desired effect or not. I think it probably will cut down some on the tendency for certain businesses not to pay, but of course there will always be, some people who continue to do that. And then this is kind of related. This goes to successor liability. So when we talk about successors, we're talking about when we have corporate transactions, say, one business is being purchased by another, or maybe changing names. Sometimes we see this. There will be businesses that rack up, citations. They may rack up judgments, and then suddenly they disappear. And overnight, in the same location, a new business appears that has a similar name. Maybe a lot of the officers and the owners are similar people, or the same people. And so what this section is adding here is that if you can show that this successor business is linked to this old business that has all of these debts, judgments, unpaid wages, various different things against them, that they're going to carry over. It's a way of preventing, deadbeat corporations and LLCs from being able to just like shed their skin like a snake and then kind of move along and just continue doing what they're doing.
And there's a part 3. This part 3 I wanted to talk about, which is very scary. Part 3 of AB 3075, it allows for local jurisdictions, such as the city of San Gabriel, to essentially enforce local standards relating to payment of wages that are more stringent than state standards. So what that means is you could actually open up an auditing division within your city to be able to come and audit businesses. So you got to be really careful about that, because now you have the state, possibly have the county, but you also have the city to be able to go after local businesses. So it's a pretty big law, new law. Definitely want to read it. You have to be very careful of it. Joseph, if you can go in under the expansion of labor code representation, labor commissioner representation.
Okay, so if we take a look at this, we're talking about actions that are in front of the Labor Commission, not obviously in Superior Court. And there are a lot of actions that are brought in front of the Labor Commissioner, and someone who brings them there can do it in pro per, which means by themselves, or they can hire an attorney, but some people might not be able to do that. And so the Labor Commissioner, they can step in and represent people who are indigent, in other words, who do not have enough money. And what this expansion does is that it allows the Labor Commissioner to represent someone in a hearing where a court has already compelled arbitration. In other words, so this case is going to go in front of an arbitrator, and that can be lengthy, and it can be costly, and it can be it can be a big deterrent to a lot of people who are just trying to get maybe a few $1,000s of unpaid wages back. So this is something that is to help a lot of lower income claimants who have good claims or meritorious claims, at least in the Labor Commissioner's opinion, to be able to have those claims thoroughly addressed, even when they're going to have to go into arbitration. And so then we move on to a little bit more about COVID. There's a lot of new notification requirements with COVID. Employers have been put under a much more significant burden now of reporting because of the COVID epidemic, as opposed to what they were required to do just, for your regular run-of-the-mill kind of exposure or injury. So the business now, what you've got to do is, once they become aware that there's a potential exposure to COVID in the workplace, they have to provide notice to all the employees, and they also have to provide notice of the potential benefits. And of course, this has to be in writing. It has to be something that you can either send out to the employees or give to the employees. You also have to tell them what kind of procedures you're going to take to be able to make sure that the workplace is safe, how you're going to try to prevent an outbreak and stop the spread, what things you expect out of the employee to do while they're there. In other words, such basic things as, masks, gloves, distancing, sanitizing, those type of things. So this kind of rolls into something we're going to talk about in a little bit, more with the workers' comp end of it. But it's basically employers having to kind of self-document what's going on at their business and sort of create a record to show if they've got a COVID situation. And in a sense, it can be used against them later on when we look at the workers' comp stuff, because if you document an outbreak at your place of employment, then that's going to have a significant effect on employees who get COVID and what happens if they file workers' comp claims.
Okay, next is diversity. Gene, if you could talk about Assembly Bill 979. That would require me to show you the slide. Gene, are you there? Probably muted. That's okay. So Assembly Bill 979. Oh, okay. All right, great.
Go ahead. Sorry, I was muted. I apologize. Did you want me to discuss it, Paul, or you can? I'm fine either way.
Yeah. Oh, okay. Let me just get through this real quick. Basically, if you are a publicly held company, you need to have an individual that is from an unrepresented community. And so An unrepresented community is going to be Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, Alaskan Native, or someone who identifies as gay, lesbian, bisexual, or transgender. AB 979, though, is very, very important in conjunction with SB 826. If you are a publicly held corporation and you are overseas, meaning that you were registered overseas, you are a publicly held corporation, let's say in China, but you have a principal executive office in California, you still have to comply with this law. I believe that there are a lot of foreign companies that are here in the US that are not going to be doing it right. I just want you to know kind of an interesting tidbit of the diversity board requirement. Asian Americans were originally not included on the diversity board. And actually there was an uproar to basically say, hey, you've included everybody. Why don't you include Asian Americans? And so this is kind of the negative story behind AB 979, which is they were specifically excluded because they were not considered an unrepresented community. So that's kind of a little bit of an interesting historical fact on it. No rehire provisions. Jean, if you can go over the AB 2143 on the no rehire provisions.
Yes. So in 2019, AB 749 was signed into law, and it prohibits the use of a no rehire provision in settlement agreements wherein the aggrieved party was restricted from working for the employer against which the aggrieved party had filed a claim. So the law currently provides a very narrow exception to allow no rehire provisions if the employer made a good faith determination that the employee engaged in sexual harassment or sexual assault. That has now been expanded, this narrow exception that now allows settlement agreements to contain no rehire provisions based on the employer's determination that the aggrieved party engaged in criminal conduct as well as sexual assault or sexual harassment. The thing is, the bill also requires that a good faith determination must be documented by the employer before the claim is filed by the aggrieved party.
Sorry about that. I was
That's all
scrolling.
right. That's all right.
Next slide, expansion for victims of crime, AB 2992.
So there have been so many laws passed, right? So we're rolling through them here. So current law prohibits an employer from discharging, discriminating, retaliating against an employee who's a victim of domestic violence, sexual assault, or stalking, or for taking time off work to obtain or attempt to obtain relief, for safety and welfare of the victim or the victim's child. The bill expands these protections set forth in the Labor Code to include victims of crime or abuse. So crime is defined as a public offense set forth in the government code. And the definition of a victim has been included to include a crime that's called physical injury or mental injury and a threat of physical injury. This used to be a limited statute for discharge, but it has expanded because, based on psychology and laws, people are victimized in so many different ways, and the intent of the law is not to make it so easy to fire an employee just because they've been subject to these various crimes, and the definition's been expanded greatly.
I'm going to go over Oliver versus Conica. So I'm just going to summarize it real quick because we want to have some room for questions. Basically, if you're commuting to work, you wake up in the morning and you go to work, when do you think you should start getting paid? Obviously, when you arrive at work. Well, Oliver versus Conica Minolta said, maybe your commute time could be compensable. So this is kind of an interesting thing because the California Appellate Court determined that in some circumstances, commute time may be compensable as hours worked. So I just wanted to warn everybody about that because this is going to continue to be litigated and talked about, which is under what circumstances is an employee allowed to be compensated when he's driving to work and driving home from work? And so Oliver versus Conica Minolta again says that it could be compensable. So I do want to let everybody know, whether it's employer or employee, this is a very, very important case for people to look at for purposes of wage and hour law. So let's talk about the issue of complying with new reporting requirements, AV 685, effective January 1st. Joseph, take it away.
Yeah, sure. So this is kind of like what we were talking about earlier, right?
Hey, Joseph, we can't hear you. Oh,
You hear me?
yep.
Okay. So this is kind of like what we were talking a little bit about earlier, is that now businesses have got to do a lot more self-reporting on COVID cases, potential COVID exposure. They've got to give more information to their employees and to people who are coming to the business. So you've got to let people know if there has been a positive exposure on your work site. And this is kind of like sexual harassment. So, right, sexual harassment can be between employees, but it's not to my contractors and other people who are coming around, right? Well, no, that's wrong. Same thing with this. You got to let, if you have contractors or representatives or other people coming to the business, you've got to provide notice to them that you've had a positive COVID exposure. You've got to give notice within 1 day of, realizing that it's happened. So as soon as the employee or whoever it is comes into you and says, hey, I haven't been feeling well, I took my test, it says I'm positive, right after you get done sending them home, you need to start giving everybody else at the business notice that, you don't target the person. You don't say, Bob has COVID, now I sent him home. You say an employee or someone here at the business had COVID, and you need to know about that. Yeah, so when you're doing this, you want to be able to maintain employee confidentiality. Like I said, you're not going to out who this happened to. You're going to provide notice to the health department. Now, different counties are doing things a little bit differently on this. So you will, if you're a business, you want to check with the county that you're working with, what kind of notice and reporting requirements they have. You've got to have a disinfection and safety plan. In other words, a plan to deal with the COVID exposure, how you're going to be able to keep employees safe, how you're going to be able to keep customers or other business or other people safe. Those things are all very important. These are the notices that are required. You have to be very proactive about this. You have also got to continue on here. Go ahead, Paul.
Okay.
Yeah, that's fine. So you also have to give, you've got to give notice here as you look at this to your workers' compensation administrator. If you're self-insured, you have an administrator who administers your self-insurance. If you're not, you've got an insurance broker and an insurance company. You have to let them know that you've had someone who has reported positive for COVID. You have to let them know the details of what that exposure is and what's being claimed. And you have to start keeping a record of how many employees are going to be getting COVID. Every one of those needs to be documented, because if you look at the third bullet there, that's what we're really looking for. It's the self-reporting to document what under the new presumption law is called an outbreak. Because if you have enough cases at your business location to qualify as an outbreak, then anybody who can confirm that they have contracted COVID during that time is going to qualify for this presumption. And if you look at it here, it does go back all the way to July 6th of last year. So, and this is ongoing as we move forward, and will stay that way until this thing is all over at some point. So you look here, this is the workers' compensation presumption for COVID. There's a couple different levels to it that are important to consider. So it goes back again all the way to July 6th, the presumption that really is operative now and moving forward. And first of all, it applies to a set class of people, mainly what we would call first responders, police, fire, skilled care facility workers who are around patients who would have COVID. Those types of individuals are going to qualify for the presumption. And just so everybody's clear who's listening to this, we talk about a presumption from a legal point of view, basically that means is that if there's no evidence at all on the issue of whether a person got COVID at work, we have no evidence, we are going to presume that they got it at work. And of course, in workers' comp, if they got it at work, they have a valid workers' compensation claim. Now, this is a presumption that is rebuttable. In other words, that it can be challenged by evidence that is presented by an employer or an insurer that shows that the person actually got it, when they were at, a 500-person disco party for New Year's. I mean, something like that. So it's not an absolute presumption. It is rebuttable. So getting back to who qualifies for it. So first responders, that group who are high risk, they're going to qualify for it. And then bullet number 4 here, which is going to be for most of our listeners and smaller businesses who are just your regular run-of-the-mill type place, the presumption can still apply if you've had one of these outbreaks. And that's why the other part of the law is requiring this self-documentation. Because if you have, say, 20 employees and suddenly 10 of them have COVID, that's an outbreak, right? I mean, that's like, you've got a serious problem there. And so this law says, okay, you've got an outbreak. So when employee number 11 comes along and says, hey, I got COVID, if they've been working there within 14 days of when, this outbreak occurred, we're just going to assume and presume that they got it at work. And then, of course, you can rebut that with other evidence, but that's how the reporting requirements we talked about earlier roll into this presumption. And that applies to anybody. That's not just first responders or police or fire. That is anyone at a qualifying business. You look at the qualifications here, 4 or more people who are testing positive out of 100 or fewer employees, or 4% of all employees of a business that has more than 100% at a particular location. So it can be location specific, right? So you've got to keep track, what percentage of people do I have that are coming down with this?
Gene, I'm going to have you jump in on supplemental paid sick leave.
Okay, I'm back. This is something that I referenced earlier. Let's say that your boss sends you home because you have COVID, you're out of leave. This is EPSL for employees who are excluded because of the large size and excluded healthcare providers or emergency responders. So supplemental paid leave is available for worker isolation, quarantine, or exclusion from the workplace. I do not know currently if these benefits have been extended or not, though, Paul. It is unknown to me.
Yep. That's right. That's been a huge dispute.
We're all waiting.
Wage and hour update.
So this is what I do most of my work is wage and hour issues. So the minimum wage is increasing, and California probably has the highest minimum wage in the country. They're tiering it up to get to $15 an hour. I know in the city of Los Angeles it is $15. That might be the case in Pasadena. I'm not sure. I live in LA County. Yep. And so there's some off-ramp provisions, and the smaller your business is, the slower the increase in minimum wage will be. And also, if you do agricultural work, I'll throw this in there. Minimum wage is the same, but there's different overtime issues. I apologize. I got off topic there. Okay. Exempt versus non-exempt. This is something that people talk about all the time. So a lot of times, a non-exempt employee gets all the benefits of wage and hour. They get rest breaks. They get meal breaks. They get paid overtime. So like me, Paul, and Joe, we are your basic exempt employee. We don't have rights like that apply to wage and hour cases. And what many employers, think that maybe they can do is like, well, why don't I just pay everyone a salary and not pay them hourly? And that'll automatically make them exempt. And then I won't have to worry about overtime. Well, of course, that's not true. Just because you pay someone a salary doesn't make them a non-exempt employee. So entry-level exempt employees must make at least twice minimum wage. Right there, being circled. So be mindful of that. And there's also other criteria that identify whether someone should be exempt or non-exempt, depending on level of responsibility, things like that. So wage and hour update. I'm going to pull this a little bit closer so I can see it. So this talks about, again, minimum wage and how it's increased over the years. We look back in 2017, minimum wage is $10.50. And then you show the exemption threshold. So I will go ahead and let's look at 2020. This chart is something that every employer should keep. I have a chart like this that I keep in my desk. If I had come up with a salaried employee, I look and make sure that they really are making, for example, in the year 2020, are they making at least, $4,500 a month to ensure that that first criteria is met.
All right, Joseph, let's talk about, again, the AB5.
Okay.
And then, and what we'll do is, just very quickly, this is a quick summary of the AB5. This is Barrello, which I'm not going to have Joseph go over because it's fairly complicated, but there's something called the Barrello Test. Did you want to talk about Barrello real quick or no?
I would just say that it's the old test. It still technically can be used, I think, in some very limited situations. But I mean, the previous slide is really the law that we're going to have to pay attention to now.
Okay. There are some exceptions for AB5 that apply to people, but I want to get Joseph to talk about AB 2257. It basically was after the Uber proposition, Uber. I forgot the proposition number. Was it 25? I actually don't remember. But this is after Uber. They passed AB 2257. So Joseph, go ahead.
Right. Yeah. So this was in response to AB5, which was very broad, as we've already discussed, in terms of really all but eliminating independent contractor from most situations. The business to business exception that we have here kind of it really falls right in line with what the new AB5 test is. But if you look at it, it's slightly different. This is applying to public agencies. So if somebody's going to be a quote independent contractor and qualify for this business, they basically have to be their own business, right? That's business to business. I mean, they have to. You look at number 2, 3, 4. Those especially, they have to have their own business location. Like we used the example before, the guy who is a heating and ventilation specialist, he's got his own shop. And number 3, he's customarily engaged in that business. And number 4, he provides it to others. He doesn't just do it for the employer that is trying to say he's an independent contractor. So if a business can show that, yeah, I am all of those things, I basically have my own independent business and this employer here is just one of my customers, then they're going to qualify for this and they will be one of the few true independent contractors. And then, of course, there are some other very narrow exceptions that were kind of lobbied into the law. There was a lot of talk in the news about, Uber and other very niche type of operations that wanted to be out of AB5, right? They want to keep, all the people that they use as independent contractors. So there are these are very limited exceptions. If you run into a situation like this, it's best to look at the exact text of the law to see whether the person could potentially still be an independent contractor. We're talking here a lot about, people in the film industry, artists, song producers, things like that, who are kind of in sort of a little bit more of a gray area than most of the, what we see usually of people trying to say are independent contractors, like field workers, or auto mechanics. These are people with a little bit more specialized skill, I guess. They kind of have their own little niche area. They may still well qualify as independent contractors, again, depending on the situation.
Gene, I'm going to have you go over AB 1512 related to security guards.
Okay, make sure I'm not muted here. Okay, so this has to do with on-duty meal and rest periods for security guards. Generally, people, are entitled to rest breaks and meal breaks throughout the workday, but there are exceptions concerning security guards because of the type of job that they do. So in 2016, class actions targeted security guards and companies because they wouldn't be giving them like a 10-minute rest break after 4 hours and a meal break after 5. But this amends the labor code to allow employees employed in this particular security service arena and a security officer who's actually registered pursuant to the Private Security Services Act to be required to remain on premises, to remain on call, and carry a monitor or communication device, because ordinarily your rest break should be uninterrupted. But because you're in this highly specialized profession, you have to have security coverage, then it can be interrupted. However, the caveat is you still are entitled to a 30-minute uninterrupted, not paid for meal break.
Well, here's the conclusion. COVID-19 really is unprecedented. So are the laws that are related to COVID-19 in 2021. We do wish you the best of luck during this very, very difficult time. However, I want to ask you, are you feeling down because of COVID? Are you worried where your business is going in 2021? Do you want to meet with a group of people that want to give you business? Join the San Gabriel Chamber of Commerce today. There are so many businesses in the Chamber of Commerce that really start off with just one person that have grown to 50 or 100 people. The San Gabriel Chamber of Commerce is one of the most active Chamber of Commerces throughout Los Angeles. And I can be able to tell you, I actually had joined previously a chamber, and after I joined, they never contacted me again. It was so painful. Not Arcadia, it was so painful. And I remember going to Sandy and I'm like, I joined the chamber and nobody, somebody said hi to me and then I never heard from them again. I don't even know when they have their meetings. But I can be able to tell you, if you join the San Gabriel Chamber of Commerce today, you will know when our meetings are. Our CEO, Sandy Roscoe, is going to reach out to you and you will grow your business. So if you are interested, if you are feeling down, if you don't know where your next group of clients are coming from, the San Gabriel Chamber of Commerce is absolutely for you. The website is sangabrielchamber.org, and our CEO, Sandy Roscoe's telephone number is right there. I did want everybody to know that we do have on January 28th, 2021, we have Randy Sotomayor. She is a specialist in mediation, does arbitration and business disputes. She's one of the few attorneys actually out there that is just specializing in the mediation and arbitration. And so being a mediator and arbitrator is very difficult. It's essentially acting as a judge and mediating difficult disputes. And that is what she is excellent at. We are so excited to have her on January 28th, 2021 at 7:30. Please RSVP, call up Sandy Roscoe as well. And this is us over here on how we are when we have our meetings. We all hug and love each other. We encourage each other, which I think is very, very difficult to find during COVID. Just a great group of people. And I just wanted to ask, are there any questions? But before I get to the questions, I did want to say, so my mom, she's in her 70s, she's very old. And I kind of get upset at her when she does certain things, as all kids do to their parents. And so she's in the backyard and she's clipping these flowers. And I'm so scared because I'm at work, right? I mean, what about if something happens to her? I said, Mom, why are you going out there and clipping flowers? You know how kids are. They love their mom, but they want to like talk to their mom, in a mean way. Mom, why are you clipping flowers? You could fall. And she says, you know what? If you don't clip them, they don't get bigger. So for those of you right now in COVID-19, you feel like things are being clipped from you. You feel like you're not as big as you used to be. Well, I believe, as well as a lot of the chamber members, that there is a universal maker, that there's someone out there taking care of you. So we really want to encourage you and to let you know you may feel clipped, you may feel lost, but I want you to know that God has done that because he wants to make you better. Just like my mother wants to make the flower more beautiful. So please consider joining the Chamber of Commerce because we want to hold you and we want to love you and we want to take care of you. We want to let you know that you have worth. So with that being said, thank you so much for joining the San Gabriel Chamber of Commerce 2021 Labor Law Employment Update. And if anybody has any questions, you could just put it in the chat. But apart from that, we were going to call it a night. So are there any questions at all that our small group of people have for the seminar for today? All right. With that being said, I wanted to thank Jean, that does exclusively plaintiff side law. I want to thank Joseph, that does exclusively workers' compensation, but dealing with both plaintiff and defendants, which is one of the very rare attorneys in California that are able to do both sides on workers' compensation. Want to thank Sandy Roscoe, our CEO, Alexis Salamanca, our current president, that has been able to handle just the entire lecture. Want to invite you and also thank you for Regina for monitoring the chat. And also we welcome you to come with Randy as she explains her practice and her thoughts. We want to wish you just a wonderful 2021. God bless you. Thank you very much. Have a good night. Bye-bye.